Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. It is great to be with you here today, as I am every Sunday from 8 to 9 a.m. on this station. If you are looking for high quality landowner information, then this, my friends, is the radio show for you, the Pennsylvania landowner. At the Clark Law Firm, I represent landowners and only landowners and oil and gas right owners. I have not, do not, and will not represent gas or pipeline companies or any other energy company. I represent Pennsylvania landowners for such items as gas leases, gas lease amendments, modifications, extensions, royalty deduction issues, unitization issues, surface agreements, surface use agreements, compressor sites, well pad agreements, you name it, any and all agreements or issues related to natural gas development here in Pennsylvania. Also, doing more and more estate planning work for my clients and landowners who are involved in the natural gas production here in Pennsylvania as well. So if you're looking for representation, you can always contact my office, 570-307-0702. That's 570-307-0702. And I want to stress that I represent clients who are located all across the country, in some cases outside of the country, but you have to have oil and gas rights, land ownership in Pennsylvania. So we broadcast the show, we broadcast in northeastern Pennsylvania, been doing the show since 2010, and we also broadcast in north central and southwestern Pennsylvania. So I have clients all across Pennsylvania, and distance has never proven to be an obstacle. And if it ever does, then certainly we'll say, hey, this is an obstacle here, and I don't think this is going to work out. However, you hear me say my favorite one, because I guess I kind of even like saying the word. It represented a client in Micronesia, and we were able to do everything by conference call, emails, fax, etc. And with today's technology, again, clients in Alaska, Hawaii, actually, Florida all the time, California, Texas. So distance is never really proven. It was never been an issue. So I just want to stress that. So no matter where you are, if you're looking for oil and gas representation, you want to learn more what we do, are we a right fit for you? Two things. One, you can give us a call, 570-307-0702, and I don't care if you're looking for representation or just good information, go check out pagasleaseattorney.com. pagasleaseattorney.com. Check out pipelineattorney.com. A lot of great information available for you, the landowner, whether, again, you want to learn more and see if maybe my office or if I'm right for you, or you just want to get good information. Go check out the websites. We archive the radio shows on the website. So if you go to pagasleaseattorney.com, you go to pipelineattorney.com, you miss today's show, you miss tomorrow's show, you miss any show over the last year or two, we have them up, available, and indexed by topic, so you can go listen at your leisure. And we put this weekend's show, we'll have it up on Monday morning, so you can check out the shows available at pagasleaseattorney.com and pipelineattorney.com at your convenience. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. And before we get into the show and the substance, I just want to remind everybody again, and I don't want to sound like a salesman, but truly, seats are filling up, and we're about 40+% capacity. And once we hit capacity, we're shutting it down, and we're not taking any more landowners who register for our upcoming seminar. The upcoming seminar is going to be, here's the details, Wednesday, June 15th, from 6 to 8 p.m. at the Dean Center in Wellsboro, Pennsylvania, which is in Tioga County. So June 15th, 6 to 8 p.m., Dean Center, Wellsboro. The details are, it is free but it is limited. It's a private event limited to Pennsylvania landowners and gas right owners only. I want to stress again, it's free. It's a private event. If you are not pre-registered, you will not be admitted into the seminar. Not trying to be difficult. We want to have landowners and landowners only. There is truly limited seating. So if you are not pre-registered, you will not be permitted that evening to enter into the seminar. And it's not like we're going to have a bunch of goons out there, but seriously, if you're not pre-registered and you're not on the list, we're not, unfortunately, going to let those people in. So you must pre-register. You can pre-register. You can go online at pagasleaseattorney.com or, and better, call the office 570-307-0702. 570-307-0702. What we're going to do then is we'll just take some basic information, verify you're a landowner, get your name or names, husband, wife, whatever the case may be, and you'll be all set. We're not going to bother you or anything like that. We just need to have you on the list and pre-registered to attend. It's June 15. It's from 6 to 8 p.m. at the Dean Center in Wellsboro. Now, I know this is a long drive for a lot of people, and a lot of people it's too far, but we'll be doing maybe other ones coming up in the future. But I really want to get out there to Wellsboro and Tioga County and talk about the very hot, trending issues that are facing the area landowners in Wellsboro, Tioga County, and surrounding areas. So if you want to attend, you must pre-register and give us a call, 570-307-0702. Okay, without any further ado, let's get into the topics of today. You know, one thing I want to talk about, and just do in the first segment, I'm going to talk about some pipeline issues. I'm going to talk about option agreements today, so stay tuned, because I don't care what it is. Whatever you're facing, if you have a pipeline agreement or you're considering one, or who knows, maybe you'll be considering one in the future, this is an outstanding topic. I'm going to talk about the option aspect, so stay tuned. It will be very interesting. Okay, before I get there, though, I want to talk about well pads. And when I say well pads, I want to talk about mutual consent in leases. And you say, what does all this mean? Okay. Whenever a person enters into a lease, you always want to be negotiating the most powerful landowner addendum, friendly addendum as possible. A very basic addendum term. When I get leases, I review leases, I represent people for pipelines or whatever comes after the lease, and there's many different things. One of the first things I do is I go to the addendum of the lease. And regardless of whenever the landowner entered into their lease, and regardless of whether they had a lawyer or part of a group, I often find, and almost typically, anytime after even 2006, 2007, when people entered into leases, and even before that, but certainly after 2006 and 7, one very common term that I see as an addendum term is language that says that if you, and I'm going to paraphrase, if the company wants to locate a well pad, roadway, or pipeline on a person's property, on the landowner's property, they must get mutual consent from the landowner. Mutual consent. However, it also states that the mutual consent cannot be unreasonably withheld or delayed. So, let me summarize. Your approach then, so what that means is a landowner who now they've signed their gas lease, they have that addendum term, and so what happens is now the company wants to put a well pad, maybe a pipeline, a roadway, but let's say a well pad for a minute. Company sends the landman and says, hey, we want to put a well pad on your property. The first thought that most people have, and I think this is unfortunate, but the first thought that most landowners have is that this is good news, because now they may start seeing royalties in the not so distant future. So the landowner, when they knock on the door, landman comes, says, hey, we want to put a pad on your property. Many landowners, in my experience, most unfortunately, think, oh, hey, this is going to be great. I'm going to get a lot of money. This is going to be really great. I'll tell you, if a landman knocked on my door and said, hey, we want to put a pad on your property, my first inclination would be, oh boy, I wish I didn't answer this door, because I do not want a well pad on my property. My wife and I, we own hundreds of acres in Wayne County, and I'll tell you, and there's no development there. I'll tell you, if we had a knock on the door and they said, hey, we want to put a pad on your property, I would just put my hands down and say, oh, shoot, wow, I was hoping this knock would never occur. Because as a general rule, in my experience, you do not want to have a well pad on your property. Now, you entered into a lease. You have to comply with your lease. So if your lease allows a well pad, well, then there's going to be, in some cases, not a lot you can do. However, in other cases, there may be quite a bit that you can do. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. We're talking about well pads here. So there may be things that you can do, and I'm talking about this mutual consent provision. But before I go deeper there, remember, okay, so if you're negotiating a gas lease and you're thinking about future pads and a pad site on your property, well, and you think, boy, I don't want to have a pad site, and you're listening to me talk, and you say, hey, I don't think I want to have a pad site, well, then you want to negotiate your gas lease terms, your addendum terms, to either eliminate or minimize the impact of a pad, or have the maximum control you can as to where a well pad will be located. For example, maybe you increase the setbacks from your house, your garage, your barn. Maybe you say you have a map attached to your agreement. Say, hey, you can't drill in this area, or you can't construct a pad here, but you can over in this area. Depending upon your acres, I've seen that, and we've been involved in those type of agreements on many occasions. So if you think you don't want a pad, the time to try to take action is when you're signing your gas lease or before, so you negotiate restrictions. Very, very important, because once you put pen to paper, now that is, I often say, your blueprint and foundation of all future relationships in contact with the gas company, and in some cases even the pipeline company. So we must make sure that we negotiate the best possible gas lease, and we minimize surface activity as much as we can, unless you truly just don't care, which is fine, but most people do. And I'll tell you what happens is most people think these pads are going to be 5 acres, maybe 6, 7, maybe at the maximum 10 acres. That's what most people think. I'm going to tell you, that's not been my experience. The last 2 pads that were presented to clients of mine, last 2 were larger than 20 acres with the roadway and pad, and that's how they calculate them, larger than 20 acres. That's a far cry from back when I remember sitting in 2000, it was late 2007, I believe, where I sat there with the landman. I sat there. I watched the display. Many other people were sitting there with me in a small group with our neighbors in Wayne County, and landman said, oh, yeah, the pad will be 3 to 5 acres. 3 to 5 acres. Then we're going to reclaim it right away. It's going to, quote, look like a golf course. Well, hey, I don't, maybe you want to have a golf course on your property. However, another case I'm dealing with right now, landowner has an enormous pad on their property and this giant wall and all this gravel all over the property that it doesn't look like the company is going to cover as far as cover with grass and planting. And this guy is not really happy at all. And again, far cry from what they understood the well pad to involve. So again, you can't address it after the fact. You have to address it beforehand. Same thing applies with pipeline right-of-way agreements, surface use agreements, compressor agreements, any agreement. You can't go back after the fact and say, oh, you know what? I don't want that pad. I didn't realize it was going to be this way. You need to get good information from someone who's going to tell you the truth. Tell you, hey, here's what you can expect. Here's what we've seen. If you sign it, and that very well, I'm not saying you don't sign it. That may be exactly what you want to do, but you may want to limit what they can do. And also, you better know what your lease says and what can occur. You know, I just see it all the time. People have these impressions. They have these discussions with the landman. So, okay, here's what we're going to do. Then later on, they call me and they say, holy heck, I never thought this. I didn't understand this. This is what I was told. Okay, you got to do better. We have to know ahead of time. So whether it's me or somebody else, if you're going to sign a document, you better be getting some assistance. At minimum, and you shouldn't wait to the end. You should have a review, consultation, understand, what do I got? Do I want to do this? What are the pros? What are the cons? These are major decisions. They can't be entered into lightly. And without the assistance of somebody working for you. Remember, you can't rely on the gas or pipeline company landman. Why? Because they work for the company. Not you, the landowner. All right, in a shocking turn of events, I'm going to have to carry this well pad and mutual consent into the next section. But it's important stuff. And we will talk about option agreements here today in today's show in just a bit. But for now, you are listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can catch me right here every Sunday from 8 to 9 a.m., and I'll be right back after this very important message. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, and I'm going to jump right into this again here. So I'm talking about well pads, but I'm also, probably more importantly even, talking about the provision that is very common in many addendums to gas leases. If you have a straight gas lease and you just sign it, for the most part, that company can put the pad anywhere they want on your property and never even consult with you, never talk to you. And as long as they comply with the setbacks, rules and regulations, how far they need to be from water supplies and buildings, houses, residents, that type of thing. So believe me, you don't want to sign a lease if you can avoid it that allows the company to have complete access anywhere on the property they want. Believe me, again, I get the calls. I get the calls from people who are sick, saying, hey, the gas company wants to put a pad on my property and they want to locate it in an exact area where I don't want it. And I say to them, well, I really don't want it here. And here's the reasons why. Company says, well, you signed a lease. You signed a lease, which is true. You signed a lease, you're bound by the lease. So when do we need to be careful? When do we need to understand what we're signing, what we're agreeing to? When do we need to restrict the company's activity on the property? Well, you need to do it before you sign the lease. You can't come back after the fact and say, well, you know what? I don't want a pad on my property. You can't do it. You can try, but nobody's going to care. So you need to negotiate the addendum terms that are going to limit or preclude surface activity, pipelines, roadways, well pads on your property. But let's go fast forward. You signed a lease. You didn't have an attorney. You didn't really understand it. You relied on the company landman who works for the company. You enter into a lease, and now you got a knock on your door. What do? Well, again, it's never too late to start making better decisions. And I mean, I'm not trying to be critical, but I'm saying we know now. We know what issues are, so we need to address them. So we need to not repeat mistakes that have been made in the past. We can learn from our own mistakes, but a better learning tool, well, maybe not better, but a broader learning tool is learn from the mistakes of others as well. Believe me, I've been preaching this to my kids, 21-year-old, 18-year-old, 2 sons. I preach it to them all the time, and I continue to preach it to them as people have preached to me. And the reason why is because it's true. We can learn. We all learn from our own mistakes. We try not to repeat them, but a broader base, you're one landowner, but thousands of landowners have made mistakes. We can look at those mistakes and say, hey, Let's us not make the same mistake, not only that we made the first time, but anyone else ever made. So let's learn from this. And now, more than ever, and it's always evolving, we're always learning more, this is a time where we can really look back and say, what do we need to defend against? What are we seeing? What are standard complaints? One thing I see, I hear this all the time, oh my gosh, I never thought it was going to be so big. I was told that it was going to be 3, 5, 10 acres. Now it's 15, 20, 25. That happens all the time. So we want to address it in the lease, in the pipeline agreement before you sign. But let's say you signed. What do we do then? You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm here with you every Sunday from 8 to 9 a.m. And if you miss any of today's show, go back, pagasleaseattorney.com, pipelineattorney.com. Tomorrow morning, Monday morning, show will be up. You can check it out, as well as many, many hours of prior shows available at pagasleaseattorney.com and at pipelineattorney.com. So, okay, let's pretend we don't have time machines and we can't go back in time and negotiate your lease, which you've already signed. Let's assume that, and let's go forward and say, knock on the door, we want to put a well pad, we want to put a roadway, we want to put a pipeline on your property. First thing you need to do, pull out your lease. If you don't have a lease or a copy of your lease, you sign a lease, many landowners have signed leases, don't have copies. Get a copy of your lease. If you're approached for anything on the surface of your property, request, if you do not have a copy of your lease, the first thing you should do, get a copy of your lease. But to avoid that issue, whenever you sign a lease, get a copy. I have clients all the time who they have issues that come up and they don't have a copy of the lease. Now, we can get the lease, but we don't want to have to go through that process. We want you to have a copy of your lease when you sign it. All right. You get a copy of your lease. First thing you do, you pull it out and you look and see what your rights are. Now, it's not always as simple as you read something and it all makes sense. You need to understand how companies operate, how they develop, how they access different units from different pad locations. There's a lot of operational aspects that may be highly relevant to what is being requested by the company and by the landman, meaning that although some activity that they are requesting may be allowed under your gas lease, other parts of that activity that they're requesting may not be allowed under the gas lease. So you may have the opportunity, and many people do, many people do, you may have the opportunity to simply refuse the proposed activity, especially pipelines, often roadways, and in some cases, well pads. You can refuse it or negotiate to find an agreement that's going to be suitable for you. And if you don't find an agreement, if you can't negotiate an agreement that's suitable for you, then you simply say, no, thank you. But you have to understand your rights. And I'll tell you, I can't say it enough. It can be extremely technical. Very difficult for a landowner, very difficult to understand what exactly your rights are and why, although a certain activity appears to be allowed under the lease, why the company does not want to do that activity under the powers of the lease, but they want you to sign a separate well pad agreement. They want you to sign a separate roadway agreement. They want you to sign a separate pipeline agreement. Think about it a bit here. Think about it. The company landman says, well, we have the right to do this under the terms of your gas lease. But here's this document we want you to sign. Well, if they have those rights, why do they want you to sign the document? And in some cases, there's a lot of different reasons for this, and this gets difficult because we don't want to give any specific advice for anybody, and we don't on the radio show. But in some cases, the company may want to have a separate agreement to simply document what has been agreed upon to avoid any future issues or litigation. in the event that there's a problem. That does occur. However, in many, many other cases, the company wants the written agreement because the separate roadway agreement, the separate well pad agreement, the separate surface use agreement, the separate pipeline agreement gives the company often considerably more authority and powers than the gas lease. In many times, and I know this is, I wish I could somehow put this into everybody that we could understand it and know it and move forward with this thought in your mind. I'll try, but think about it. Remember this. If a company has the power to do something under the gas lease, such as well pad, roadway, and especially pipelines, if they have the power under the lease, in most cases, when your lease ends, when it terminates, so does the gas company's authority for that activity. And let me explain that a little better. What I mean is, let's talk about pipelines. If a company says, well, we have the right to install a pipeline under your gas lease, well, maybe that may be true. However, if you install it under my gas lease, in almost all, but not all, but almost all cases, if you install a pipeline under my gas lease, when my gas lease ends, when it terminates, so does your right to have that pipeline on my property. So you want to play hardball, company. You want to say, oh, we'll put it in under your lease. Well, sometimes they are bluffing. But again, no specific advice anywhere here. But you got to look at it because they may want to put it in under your lease. Well, what if your lease expires in 50 years and that pipeline is going to be carrying gas from all across the region? And that pipeline, they want to have it for another 100 plus years after your lease ends. So you may have this hidden leverage or authority to say, hey, no, I'm not going to agree. Go ahead and put it under my lease. But I'll tell you what, company, first off, we're going to review the lease, make sure that you're following it. And if you have specific language about pipelines and what's going on there, well, then you're going to have to comply with that. Oh, and by the way, when my lease terminates, so does your rights to use that pipeline. And I've been down this road many times. So gas lease terminates, so does your right to use the pipeline that you installed under my gas lease. Again, please take that in. Not specific advice for anybody, but remember, if a company installs a roadway, pipeline, we'll stick with those two examples, and they say, we're going to do it under your lease. You don't reach an agreement, and they say, we're going to do it under the lease. You say, fine, but you have to comply with my lease, and when my lease ends, that roadway has to be gone. And why are companies asking for separate pipeline agreements, roadway agreements? In many, many cases, because if you sign a separate pipeline agreement, that pipeline agreement is now going to be what dictates how long that pipeline can be there. And I'll tell you this, you can ask the guys, ask the landman, ask the company, oh, you know what? I'll do this separate pipeline agreement, but I want an addendum term that says this pipeline agreement terminates simultaneously with my gas lease. So when my gas lease ends, so does my pipeline agreement. And you're going to find that the answer is, well, we can't do that. Why? Because part of the reasons why they're giving you or want you to sign another pipeline agreement in most cases is because they want the additional authority that comes with the pipeline agreement. The fact that maybe they can transport foreign or third-party gas from across your county, neighboring counties, and so on. Maybe they want to have the power to have that pipeline there forever, where if you didn't sign the agreement, in most cases, the vast majority of cases, the right to have a pipeline on your property terminates whenever your gas lease terminates. Look, are they telling you that? Well, you tell me. I mean, are you being told that when the landman comes out and sits down with you? I tend to doubt it. But maybe they do. I don't know. I haven't heard it yet. But anyway, We got to know these things. And then you have to apply it to your specific situation. As always, it's not what I talk about is never specific advice for any landowner. My specific advice for every landowner is get assistance, whether from me or somebody else. Get assistance from somebody who knows what they're doing in working for your side. I am extremely confident that there are many landowners who have signed pipeline agreements because they thought they didn't have a choice. And I mean, I'm talking hundreds of landowners. I've never, ever had a client with a pipeline agreement that we were not able to negotiate to considerably increase compensation in many cases, but at minimum, the language, to negotiate the language, to negotiate the location. If you're signing a pipeline right-of-way agreement that allows the company complete access to anywhere on the property to put a pipeline, that's a foolish move. And I'm sorry to say it's a really bad move because you don't need to do that. You really don't need to do that. And if you're doing that, you're making a big mistake because that can come back and haunt you. And I say, I deal with those calls with the landowners who signed, who didn't contact an attorney who knew what they were doing, who believed in what they were being told by the landman and said, okay, I'm going to rely on them for my advice, even though they work for the company. And then what happens is, then there's a problem. All of a sudden, there's 2 lines, 3 lines. They're digging it up again. They're putting it in a location that you were told wasn't going to be the case, but you signed the agreement. The line that comes back all the time to haunt landowners is, well, you signed a lease. You signed a pipeline agreement. You signed a roadway agreement. So you have to live by it. And then you're going to hear that time and time again. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here with you every Sunday from 8 to 9 a.m., and I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark. And again, I'm here with you every Sunday from 8 to 9 a.m. right here on this station. Okay, I'm going to tie some things together here. I started talking about well pads and mutual consent. So let me finish that quickly and then we'll talk pipelines. So what I'm talking about is if you have, remember, knock on a door, company landman says, hey, company wants to put well pad, roadway, pipeline on my property. First thing you need to do, get your lease. If you don't have it, get it, request it from the landman. But you need to have your lease because you can't tell what your rights are if you don't have your lease. And what does that tell you also? Well, before you sign a lease, you better negotiate it to make sure that you get as many protective terms that you can. One very common term is a term that says that if the company wants to put a well pad, and usually it's roadways and pipelines also, the company has to approach you, the landowner, get your mutual consent or your consent, but that consent cannot be unreasonably withheld, conditioned, or delayed. Well, what does that mean? Well, that's not a black and white line there. That's a lot of gray area. And the companies will typically want you to believe that you have very little rights there. And the companies love to tell people, well, this is the only place that we can put it. And if you didn't agree or you don't agree, they like to tell you you're being unreasonable and we're going to put it there anyway. Well, if you're in that scenario, you better get some assistance. And you should get assistance quickly if you're asked for a pipeline, roadway, or well site. Get your lease, consult with somebody who knows what they're doing, and understand your rights. And the company wants to often say, again, if you don't agree with what they're presenting, they say, hey, you're being unreasonable. We need to put it there. To my mind, there's a lot of strong-arming and bullying that's occurring with well pads, especially, but other projects as well. So you need to talk to somebody. You need to understand your rights, and you need to understand the process and what you can do if you don't like the location of the well pad. Don't be bullied. If the answer is, hey, look, I think you don't have a lot of choice here. It seems like you're not going to be able to defend against this. Then you can decide, do I want to sign this agreement? Or just say, fine, company, use my gas lease, locate the well pad. That very well may be the decision that you want to do. but you need to understand your rights. So if you have mutual consent for location, don't be afraid to use it. Again, never specific advice for anybody, but don't just give this up. It is a powerful provision when used properly. So you don't just simply say, oh, well, I guess I'm being unreasonable. This is what we need to do. I've seen many times where companies have said the pad has to go at this location. The landowner didn't want it there. The company says, well, landowner, you're being unreasonable. Landowner says, I'm not going to sign. I'm not going to agree. I'm not going to consent. And I've seen several cases where the company has relocated the pad. They're not going to sit there in that first time and tell you, oh, well, since you said no, we'll just go ahead and move it. Sometimes you have to say no again, and no, I really mean no. Once again, though, never specific advice for any individual. If your approach for a pad, roadway, or pipeline, the first thing you should do is call somebody. Call an attorney, oil and gas attorney, who knows what they're doing, who has experience in these areas, and understand your rights. You don't want to sit there and be overly aggressive when you don't have rights, but you also don't want to roll over when you have rights, because you may be able to move the pad, you may be able to move it off the property, you may be able to move the roadway, the pipelines, you may be able to say no. There's a lot of different things that you might be able to do, which needs to be looked at on an individual basis. We have to look at it, and you need to have specific individual advice. But don't just roll over. Let other people roll over, not you. Don't roll over. It gets back, don't roll over. Don't be a signer. Don't just sign things. Don't just sign documents. Don't just roll over when you're told, oh, well, we can do this. Find out. Can they do it? What are my rights? Can I say no? Can I negotiate? Can I change the language of the agreement? And usually the answer, at least to one of those questions, is yes. And many times you can say no, especially pipelines and roadways. So I'm going to leave that there now, and we're going to talk some more about pipelines. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here with you every Sunday from 8 to 9 a.m. Okay, switching gears now. Well, kind of not switching gears, but talking about pipelines. We're going to move off. Now, before I do, though, talking about mutual consent for the well pad, well, you may also have mutual consent on pipeline locations. Don't be afraid to use that either. People are not taking advantage. They're not using the mutual consent addendum term in their gas lease. They're not using it, rolling over on it. Don't do that. Just because the company says you're being unreasonable doesn't mean that you're being unreasonable. They're not the judge of this. They're not the jury of this. That's their opinion. And a judge or a jury may have a very different opinion. And you certainly may have a different opinion. So do not roll over on the mutual consent provision in your gas lease. Don't do it. And also, transitioning the pipelines. Don't, just because a pipeline may be allowed, may be allowed. You may have authority under your gas lease to negotiate location, which then can give you subsequent authority to negotiate a whole lot more. Personal advice, that's what you need. All right, pipelines. I started at the beginning. I want to talk about pipeline options and option agreements. And I can tell you, I could do shows on this. I could do multiple shows. There are very few issues that get me more fired up than pipeline right-of-way agreements and what landowners are being told and what they understand. We need to have informed, educated landowners who make good decisions with good information. That's what we need. And unfortunately, in Tioga County, listen up, unfortunately, we're seeing people sign horrible, in my opinion, horrible, terrible pipeline right-of-way agreements because I believe they don't understand their rights. I really believe that. So if you understand your rights and you want to sign an agreement, that's what I do. That's what you do. That's what anyone should do. There's thousands of contracts signed out there. Many of them, people understood their rights. They negotiated the contract. They entered into a contract they were comfortable with, understanding all of the terms, how it would apply to them, and elected to do it. I've had hundreds and probably thousand plus clients who've done that. We enter into agreements in a vast majority of cases, but we enter into good quality agreements that have been negotiated to obtain what we think is the best possible agreement in that circumstance. That's what we do. But one of the things that's happening is landowners are signing pipeline right-of-way option agreements that, in my opinion, and I have negotiated and been consulted with pipeline agreements with over 60 different pipeline and gas companies across Pennsylvania. So I have a little bit of experience on this, that many people are signing really bad pipeline right-of-way option agreements. And one thing that you should not do, in my opinion, and this is my strong opinion, you should not sign pipeline right-of-way option agreements that are two separate documents, meaning one document is what's called the option agreement. Another document, a separate document, is the pipeline right-of-way. And I'm going to explain what I mean. If a company landman comes out and says, "Oh, we want you to sign a pipeline right-of-way agreement. Here is the option agreement. Here is the pipeline right-of-way agreement. Put your pen down. Call 570-307-0702, or honestly, call somebody." But there are fatal issues, in my opinion, with these documents that you need to avoid. And in my experience, no client of mine has ever signed a separate option agreement for a pipeline right-of-way and the pipeline right-of-way itself. We can combine those and make them one document. I'm going to explain more what I mean and what I call the landowner option dilemma when I get back after this break. You're listening to All Things Marcellus with Attorney Doug Clark. I'm here every Sunday from 8 to 9 a.m., and I'm going to be here again after this extremely important message. Okay, welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Here we go. We're going to jump right into it because we got a lot to get to here in a short segment. So, okay, pipeline right-of-way option agreements. One thing that several companies do out there, Susquehanna Gathering Company, repeat, Susquehanna Gathering Company, Howard Energy, repeat, Howard Energy. They'll go out, they offer the landowner a pipeline right-of-way option agreement. That pipeline right-of-way option agreement has more than one document to it. And I'm going to talk generically now because I know there's different agreements that companies use, but here's what I want you to watch out for and what I want you to pay attention to. If you're offered an option agreement for a pipeline right-of-way, I personally never want to see anyone sign an option agreement and then a separate pipeline right-of-way agreement. Most of these agreements tend to be constructed this way. If you sign the option agreement, that is a whole agreement about the terms that have to occur or what the company's rights are to decide whether they're even going to use the actual pipeline right-of-way agreement that would set the actual pipeline right-of-way on the property. The option agreement is an agreement about a company's option, their choice of whether to move forward. So, multiple things here. One is, company comes out, offers you $1,000, offers you $600 to sign an option agreement, which then gives the company 2 years, maybe 3, maybe more, in order to decide whether they want to use the actual right-of-way agreement. So now here you are as a landowner. Big dilemma. In my mind, not really a dilemma at all, but for you as a landowner, big dilemma. Company is offering you an agreement, and company drafts the agreement. Agreement is very company friendly. Of course it is. Then company says, well, we want you to sign this. And you say, well, I know that these agreements are drafted heavily in favor of the company to give the company many options, loopholes, abilities to decline, delay, all kinds of things can be written into these contracts. So hey, I need to protect myself. I need to protect myself. So I need to get an attorney who knows what they're doing, who can assist and help me, who can at least consult with me and explain everything to me. But there's going to be a cost involved in that. So the company, you want to give me this agreement that you drafted, and you want to pay me $600, $1,000 to sign this agreement, but that's not even going to, and maybe it does, cover attorney fees, depending upon what's all involved. So as a landowner, you have this dilemma. I got this agreement that I know is drafted by the company to benefit the company, not me, the landowner. But the companies are smart. They offer you, all right, we're going to give you $500, $600, $1,000, and we're going to give you that to sign. But we know if you go to an attorney, you may have to incur expenses or fees in excess of $500, sometimes more, depending on what's involved. So it deters you as a landowner. You say, well, geez, I certainly don't want to only get $600 and I got to pay taxes on that money. I don't want to get just $1,000, pay taxes on that money. But then when I get done doing the work that I need to do, that I should do to protect myself, well, those fees and costs may have exceeded that $500, $600, or $1,000 the company is offering me. So I'm stuck. I have a dilemma. Do I just sign? Do I just sign this agreement that I know is drafted by the company for the company? Or do I go get an attorney and then when I go through this process, if the company doesn't exercise the option, so all I got is $600 and I have a legal fee. Let's say the legal fee was $600 and I paid taxes on my money. And then the company decides they're not going to use this agreement. Well, now I just lost money. I lost money. And who wants that? I certainly wouldn't. And as an attorney, I certainly don't want to see that happen to my clients. So you have a real dilemma. Companies say, well, hey, we don't care. Here's your agreement. We're going to give you this. Get an attorney if you want, but we're only going to pay you $500, $600, or $1,000. My first thing is, as a general rule, not specific advice for any specific person, see you later. Not doing it. Not going to do it. Or you have a review and consultation with somebody like me, but you do that and you understand your rights and you decide, do I want to go forward? Very often we can negotiate higher option payments. I've had option payments as high as $25,000 for signing. Actually, I've had them more even, but you want to negotiate that. You don't want to come out in a situation where you need to protect yourself. You need to protect yourself. Many of these agreements don't even give you liability protection in the event there's a death, injury, or accident, and you get sued. You got to protect yourself. So you're in a position where you have this dilemma where I got a bad agreement. I know it's a bad agreement, but if I go to an attorney, I might end up losing in this deal. So why am I even going to consider it? Why even consider it? And in most cases, if I have the right to say no, I'm not even considering such a deal. It's a bad deal. Not going to do it. And you know what would happen if everybody did that? Everybody would get better deals. But we got to get the information out there. We got to get it out there. Don't be bullied. Don't be bullied. I have routinely clients get $60 a foot for pipelines. Not every case is the same. I've had clients get hundreds of dollars a foot. I've had clients sign for $25 a foot. But I'll tell you what, I haven't had a client sign for $15 a foot in I don't know how many years. So we need to, again, lift everybody up, to inform everybody to understand your rights. And I want to stress again, not specific advice for anybody. My specific advice is get an attorney who knows what they're doing and get individual advice for you. But these are things you need to be thinking about. Also, I talked about why don't you want to sign a right-of-way agreement and an option, two different documents? Well, look at these option agreements. This is fascinating, guys. Fascinating. I swear it's fascinating. It's almost unbelievable. These agreements, these option agreements tend to have language that says like this. You sign an option agreement document. which may be 5, 7, 10 pages long, pretty long. You sign an option document. And what happens, you also sign a right-of-way agreement. That right-of-way agreement is attached to the option as an exhibit. But the option agreement, many of these say that if the company decides to put the pipeline in, you will get a new right-of-way agreement, and you agree to execute that agreement. And that agreement is new. It's a different document, but it's going to be substantially similar to what you have already signed, but it can be different. Don't do it. Do not agree to an option agreement where in the future you have to sign a right-of-way agreement that you haven't even seen yet. What happens is they say, okay, sign this option agreement, and we're going to attach a right-of-way agreement to it as well. And in the future, if we exercise the option and want to use the pipeline, we're going to then come back and we're going to give you another pipeline agreement to sign, which has to be substantially similar and other customary or common terms. Well, what are those? Do you know? If you do, call 570-307-0702 and let me know. Let me know, because what is customary? What are you going to be fighting about then? What if you don't see something as customary, but the company does? You got to be careful, guys. I just don't want to see people sign these. None of my clients ever have. If you negotiate it, you can get rid of it. But boy, you don't want to come back and have a problem in the future. And as I say to my kids all the time, nothing's a problem until it's a problem. So, though your neighbor may have gotten through and didn't have any difficulties, they didn't have a problem. But boy, if you have a problem, now you have a problem. So, we need to avoid problems before, not deal with them after. But if it's too late, then we deal with them after. But let's avoid the problems. And I'm going to leave it with this. Remember, nothing's any individual advice for anybody. But if you're given an option agreement, which is, well, if you have any pipeline or right-of-way agreement, but if you get an option agreement and it's a separate document than the pipeline right-of-way agreement itself, call my office. Let's talk about it. Do at least a review consultation. Take an hour or two of time. Talk about what the problems are and decide if you want to go forward. Don't be bullied. Don't be tricked. Understand your rights, whether it's me or somebody else. Get assistance for you. You can call me 570-307-0702. 570-307-0702. Okay, I got to leave it there, but I want to remind everybody again, you must pre-register, and you have to be a landowner, and we're checking. We got to get verification information from you. But free landowner-only seminar, private event, Wednesday, June 15th. Wednesday, June 15th, 6 to 8 p.m., Dean Center in Wellsboro. I'll be there talking about hot issues, answering questions and concerns, especially issues facing Tioga County and that area landowners. To attend, you must be pre-registered. Contact 570-307-0702. If you're not on the list, unfortunately, you're not going to be able to attend. Free for pre-registered individuals only, must be a landowner, cannot work for a gas pipeline company or any land service company. Pre-register, and I hope to see you there. I'm out of here. Have a great week, everyone.